who died first.
Yeah. So do you want to talk a little bit about the way, we won't get in gruesome detail here.
No, but which I know we had talked off camera about how it's so hard to wrap your head around the fact that, he's a famous guy, he's got a lot of money, and they didn't have someone checking on them on the daily.
And we'll talk more about this because it does trouble me.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
So we're picking up with part 2 of our show about Gene Hackman and his wife, Betsy Arakawa. I hope you enjoy this episode. If it's a standard pour-over will, though I've not seen this reported as the case, but if it's a standard pour-over will, you have a trust in place, then you don't need to say, I give it to I give this person these assets, et cetera, all the things you'd normally say. You've already said it in your trust. So you simply say in this pour-over will, which is what it does, it dumps it into the trust. It says, take whatever is in my estate, dump it in my trust. That's it. So the trust is the entire beneficiary, everything. So if that's what happened, then all this talk about what was added in the will beyond that is really kind of moot because there wouldn't be such content. So I am a little troubled by the fact that I'm seeing discussion of people of there being provisions in the will in which things are given, all to my wife, for example. That would be really odd. Why would you give it to your wife outside the trust? Why not say to my trust, which we know or we're pretty confident. We haven't seen, again, trusts are private, but we can be pretty confident that it's saying all to survivor, as if there is a survivor at that time. So it's frustrating that I'm hearing that actually this will does seem to have provisions disposing of these assets to the wife, for example, to a charity in some cases. I've seen mention in one source that the kids are named at the, as a final contingency. It just doesn't make sense that you would do it that way. But it could have been because it's not as if these were done at the same time. Normally, your trust and your will are done hand in hand, so that they're signed. They're signed simultaneously, and when they're simultaneously, they're part of one regime. One set of rules governing your estate, and it's very organized. It considers all contingencies, et cetera. But let me mention this just in passing is that, one of the advantages of putting things in your trust already is that you avoid often the probate costs that, can be substantial. These are governed by legislatures. And legislatures, guess who run legislatures? Lawyers. So if you look at your state statute, not every state has this. Missouri has it. Illinois has it. And I think the majority of states have provisions that suggest what the rates or how lawyers should be paid relating to their services in estate and probate. And they're pretty generous terms. And generally, they correlate to the size of the estate, for example, a percentage of the estate. So if it goes through probate, even though it may be utterly clear that it's simply the instructions are take this pile of assets and dump them in my trust and shut down and pay my creditors and be done with it, still the question becomes how much were those? And whoever the lawyers are that are involved, can typically say, oh, well, the value of that was $1 million. In this case, well, it wouldn't be $80 million in this case, but it would be, let's assume it's $30 million. So, 3%.
Somebody's going to want their cut.
That's a big cut. So you don't want to just run things through your estate needlessly. If you can avoid running it through your estate, you do. And I think I'm betting that there were a significant amount of the assets that were in the trust, but we don't know. So whatever wasn't will be governed by the terms of the will. Now, let me mention, though, that scenario where you have a will, and let's assume there are a lot of assets that were in the will in the will in some way, and let's assume that there wasn't reference to a charity. So you have essentially a bequest, or you have this term in the will in which Gene Hackman says, well, I'll give to my wife whatever's in my estate when I pass, and signs it. In that case, it does raise an interesting situation because you have assets that, again, were in the estate, not in the trust. So that means that the court has authority. And now there's no one to give it to. So you might say, depending on the law of New Mexico, it could be that you have intestacy as to those assets. And if you have intestacy as to those assets, intestacy means that there's no will, meaning as to those. It means that the court can do a couple things. I'll tell you the most common in many states would be to look to the rules of intestate succession. But there is some authority for the court saying that in that case they want to look to what were the priorities expressed by the person who's deceased and try to interpret what they would do regarding those assets. It's kind of like they forgot something. And so what do we do now? And both views have some legitimacy. There's certainly legitimacy for saying, look, this person could have put a contingency beneficiary. They didn't, apparently. And incidentally, you can understand Gene Hackman's 95. She's 65. And I want to say in very good health.
Yeah. You thought? I mean, she was.
Despite what happened. And we'll talk about the order in which they died in just a second in more detail. But so he thought, what are the chances, that she's going to predecease me? So in that case, what one could say is that it was an error. And if the court interprets it as an error, then they could legitimately say, well, then why wouldn't we take this and figure out what he would have done with it in that case? That, what would his intentions be if we know a lot about him? What if we had somebody who, let's throw in a few facts, where they had this awful relationship with kids, right? The kids had a terrible relationship. So in that case, would you want to say, what are the laws of intestate succession when you know that those are probably going to lean toward the children, toward their natural objects, such as on the family tree? Look to a sort of filial relationship or relationship parents or ancestors. Most of the intestate succession laws in every state correlate to a familial relationship on a family tree. Generally, children typically come first, parents second, siblings third. So that's just kind of the general rule. So if you know that the only ones living among those are people that this person hated, then it wouldn't seem to make sense to do intestate succession.
Yeah.
And so it would make sense to, let's try to take evidence to explore what he wants. But the argument for intestate succession is that, look, this is what the law has said. If you fail to provide for somebody in your will, or that you fail to do a will, is what the law usually envisions. That's when this comes up most commonly. And so what would the person have wanted? It's more about, what do we know is the most likely scenario, and we're going to impose that as the default switch when this happens. So everybody knows that, if you're a resident of the state of Missouri or you're there and you do your estate planning, it's public, you can count on this will be the default switch. And if you've accomplished letting, and this is a bit of a legal fiction, but the idea is that the world knows, like when you pass a law, it may be a legal fiction, but it's taken very seriously. You're presumed to know the law. And so you can plan your life around that. And because of that presumption, you can assume that as to taxes and everything else, you engage in things with this idea that I want to accomplish this. And so in a way, by knowing that you have this certainty that if you fail to do your estate planning, this is what we're going to do with it. So somebody who goes out who's thinking about estate planning their last days, we definitely don't. No lawyer recommends this. But the point is, if you know what the intestate succession plan is in the estate, then you at least go out of the world saying, okay, I know this is what's going to happen. So in this case, one could argue, is it possible that Gene Hackman knew? Now, this is a legal fiction, but the legal fiction would say, why would we necessarily upset this when he had reason to know? He had lawyers, and they certainly would have told him that by not adding anything else, it's going to go to your kids, because that's intestate succession.
And maybe that kept his relationship with Betsy on the up,
now
because
see,
he never mentioned that.
It took you to
Didn't
think.
come into the kids.
It took you to think of that.
Well, and I was also thinking the kids, if it gets down to, we're going to give it all to charity, well, guess what? We've got the new Gene Hackman charity, and all kids are working for the charity. And there goes the money to the charity, and they get it.
So no, but it's true. Your mind works differently. You can maybe see this in a way that I wasn't thinking. But yeah, of course, you could have something like that where, in order to keep peace in the family, their kids aren't named. All I'm pointing out here in this argument is that there are two legitimate approaches. On the one hand, some people who are watching this, you're thinking, well, wow, if you know that he hates the kids or that he hates this. Let's not use kids. Let's say brother, and the brother's the only living heir. So you think, well, why would you possibly give it to the brother when you know he doesn't like? And yes, that's this view, but it means that there's always uncertainty about intestate succession if the same rules are going to apply. Whereas in the latter case, it has its deficiencies too. But so I don't know if I'm betting on what would happen. I would bet that the kids that if in fact there's a substantial amount of assets in the estate, not in the trust, and that there's a failure to name an alternative or contingency beneficiary, I think these kids are probably going to be in a good position to take those assets.
I would guess that too.
But now let's talk about the circumstance of the death, because it's going to bring into this discussion the issue of simultaneous death statute.
Yeah.
So
who died first?
Yeah. So do you want to talk a little bit about the way we won't get in gruesome detail here?
No. But which I know we had talked off camera about how it's so hard to wrap your head around the fact that he's a famous guy, he's got a lot of money, and they didn't have someone checking on them on the daily.
And we'll talk more about this because it does trouble me. But what we know, as a matter of fact, is that apparently Betsy had this. Is it a respiratory thing?
Respiratory that apparently is carried in rats and mice.
Yeah. So
she caught that.
She developed this respiratory thing, and I wonder, was the home really well kept clean? They apparently didn't have a full-time staff working there. So anyway, she has this. They have dates of when she was actually doing errands. She was moving about.
Got some dog food.
Yeah, made some phone calls. Meanwhile, Gene Hackman, we know some things about him because he had these electronic devices.
Yes, he had the heart issues, and then he also, of course, had Alzheimer's.
Yeah, so it's estimated then that they died on what days?
At first it was the 11th, and then they changed that for her to the 12th because they did some digging and they found that she had made a phone call to a doctor. Mm-hmm. And she had also gone online and sent an email. He, on the other hand, however they do their stuff, the forensics, that he probably died a week later because that was the last time that they saw some movement on his heart, monitors.
So, and we think then that, so the updated day, going from the 11th to the 12th, that still leaves how many days between?
It was 8 days.
8 days. So, and this, of course, is important because of the Uniform Simultaneous Death Statute, which New Mexico has adopted along, as far as I know, every state has it, some form of it. And many use what is the standard length, which is 120 hours, which ends up being 5 days. And there's nothing magical about this period, but it does make a whole lot of sense to have a law like this. And the reason is that in the absence of this, I mean, it's hugely important potentially in often cases when you have two people, each of whom have named each other to inherit their estate, and let's assume beyond that each would have substantially different contingent beneficiaries. So they each name the other, but then the next choice becomes somebody of their own interest, and which is probably more common than not. So you have two people that die in a car accident. So now not only is there the question of who, in fact, is going to end up getting their estates. So there's that big question. Mm-hmm. But even if you had if it was an intact family, these were parents who had same kids, same grandkids, and all stated, had the same list of beneficiaries, you still end up with two sets of probate, and that it creates incredible costs, can have some tax implications, of course, but beyond that, just a lot of cost. And so it was a long time in coming, but these statutes started coming on the books, I think, in the 50s. Been around a long time. And they really solved a huge problem in estate planning and in probate. So this 120-hour rule simply makes the presumption that if somebody dies within that period, if there's not more than 120 hours between the death of the two, then in that case, it's presumed that each had predeceased the other. So in other words, what it does is as to each person's will, it wipes out the other person as the primary beneficiary, and then they go to that next layer, the next contingent, or to the contingent beneficiary. And again, unless it's the scenario of an intact family who has kids and each had named the kids as getting everything, same people. Absent that, then it produces a different result. But it ends up, in each case, if you think about it, with the assets going to that person's most important person next to the one who had died. Meaning after that person, those assets can go their own way. But it's done efficiently. It's consistent with what each had that after the other person died. It's consistent with that. And it saves a lot of money and a lot of expense.
And that's coming from a lawyer.
Yeah.
Saving money. No, jeez.
and well, I'm telling you, the lawyer expense,
that's the biggie.
If you look at the cost of the planning and the cost of the estate.
Yeah.
I mean, but in this case, I'll talk more about taxes in a minute. So let me wrap this up, and then we'll talk a little bit about the whole subject of tax planning. So in this case, though, oddly enough, these were outside that rule. So yes, there will be an estate opened for each of them. Mm-hmm. And you may say, well, gee, that's still kind of inefficient, which it is. But the good news is that I think that there won't be as many assets in Betsy's estate. And there's also the possibility as to both that, in fact, they're going to be in this trust. It could have been much worse if it turns out that Gene Hackman did name his kids as his, choice after her, because had it been the other way around, had Gene died first, which is what anyone would have predicted, then in that scenario, it would mean that the kids are definitely getting nothing unless they find some way to attack the will based on undue influence, et cetera, coercion. So these occurred in a way actually to where there's probably fewer assets in her name, I'm betting, and hers will be a simpler estate. And it may be that her provision that everything in her name goes to her husband or to his trust, which accomplishes the same thing. So that could save a lot of cost and hassle. So in my opinion, it's better the deaths occurred in this order than the other way around, where all the assets would go into her will, which means to her charitable causes. She did have a provision, and I don't know if it's accurate or whether it was speculation. One source that I read, and you told me you read this too, that there's a number of days that she specified in her will that if their deaths did not occur beyond that period of time apart, that she wanted to override her first choice, which would be her husband, and have it go to charity.
Yes.
That's not unusual. Now, the Uniform Simultaneous Death Act is just a default provision. It's like a lot of provisions in probate and in other areas of law, but I would say especially in probate, is there are more than suggestions because they govern in the absence of you choosing something different. But the whole idea is that if you choose something different, if you want to say, gee, I don't want 120 hours, I want 90 days. Yeah. Now, it does hold up ultimate resolution of the probate process. So at some point, the court and public policy has an interest in overriding people's preferences. But we know that it has been approved in some courts up to 90 days and probably beyond. So in this case, what I had read was 30 days.
Okay, yeah, I saw 90, but
So it could be either one of those, or it could be neither. But it's worth talking about because it's not at all inconceivable that she would have such a provision. And it does mean that whatever was in her name individually and not in a joint trust or in her individual trust, it means that it would be governed by that provision. And so it wouldn't go automatically to Gene Hackman's estate or to Gene's trust. We don't know about that. It would, I wonder to what extent she was committed to these charitable causes. So it makes me question whether she would have that 30-day provision. And it does seem so prophetic, because you would not expect her to be saying within 30 to 90 days of the two of them, given 30 years difference in ages. You just, it's...
Is there a cover-up?
It seems like well, you never know. But
where can we be going with this? Yeah.
It is a different scenario, and we're just alerting you to that possibility. I don't think it has grave implications either way, because I do think most of the assets are going to be governed either through Gene's trust or his estate, and then his trust, hopefully. Now let me say a couple of things though about the estate planning as terms of taxes. An $80 million estate, you want to do what you can to move your assets into irrevocable trusts. So often people with a substantial amount of assets, and I've talked a little bit about this in a recent show, so you can look it up. It would have been a show in the last 2 weeks. But there are a lot of reasons that you want to move your assets when they're of less value into an irrevocable trust, not a revocable trust. And you do that knowing that you surrender some control, but in exchange, you get to lock in the value of that asset at that time, so that if you die 30 years later, if it's like most assets, it's probably appreciated a lot. If it's real estate, if it's your intellectual property, a lot of things tend to go up in value over the stock market if it's a typical portfolio. So there are things that you can own, and if you think that you have enough of a runway before you die and these become subject to taxes, you can go ahead and move them into an entity that is treated like a separate entity. And in order for the law to recognize that as a separate entity, it has to be irrevocable. It has to meet a number of other terms, which I've discussed in much more detail in this recent video. In this case, I've not read any mention of an irrevocable trust. So that creates a substantial amount of tax liability at the death of the second spouse. Now you have this marital exemption, which essentially is unlimited, which means when husband and wife die, no matter how much the assets are, that you can postpone paying taxes until the death of the second one. This is a provision that's been around for many years, and it's intended to recognize that the husband and wife are a unit, and that when the latter dies is really when there's a real transition of the assets. They're not really being transitioned to the surviving spouse. So just for the surviving spouse having to pay taxes for something that she's lived and possessed and whatnot in all meaningful ways as before, and yet now she's surrendering a substantial portion of that, seemed unfair. So IRS long ago recognized that we're not going to tax this until the second spouse dies. In this case, though, it's true that there was, this exemption was beneficial for 7 days, right, or whatever it was. But then it's going to be due, and the rate at which assets are taxed in an estate where you have, let's see, the top marginal rate now is 40%, and it climbs. It's a very steep rate, so it means that you reach that 40% rate, 39 point something rate after, $15,000 or so. So in other words, it's real steep. It doesn't go up very gradually. So you hit, 40%, for example, after you get to $1 million or $2 million or $3 million. Now you do have an exemption, And the exemption, assuming that it's claimed for each, which it will be, so you have an exemption of now it's what, $28 million is the total exemption, believe it or not. So that much will not be taxed. But beyond that, and if these numbers are right, take $50 million and take essentially 40% of that number. And incidentally, I don't know if there's state inheritance tax in New Mexico. I assume
So if the kids were to get this, they might not be able to afford it anyway. Because if dad made all these millions and the kids were just
well, the tax would have to be paid in some way. So let's assume then that it's $50 million and it's a 40% rate. So it's what, $20 million? That's a big chunk to pay. And not that I'm not saying can necessarily been avoided entirely. I'm suggesting that the bulk of that could have been avoided entirely. And yes, it's possible to definitely have avoided all of it entirely with the proper planning. And when here we have somebody who's a celebrity in the 90s, he has a lot of money. There's simply no reason to have not done that planning in the 90s. Mm-hmm. So again, we don't know everything here. So it's possible that he did that. Yeah. If he did that, then all this talk is going to regard assets that, are going to be relatively small in amount, less than 25. You can leave 25 million exposed to taxes, or 28 now million exposed to taxes. But to have not done something, and believe me, it's not at all unusual. Rich people, famous and not famous, regularly do not go to the trouble to create these trusts. It's expensive. You pay a lawyer $20,000, $30,000 sometimes to do that sort of thing. It's not unusual to pay that much. Not necessarily have to, but it wouldn't be unusual. So and they lose some control. They have to follow rules. There's no free lunch. So if you want to transfer your assets to another entity so that you capture whatever the value is at that time, and that's all you pay a gift tax on that value, not the value in 30 years.
Yeah, just the gift tax.
Yeah, and the gift tax, would be at a similar rate. But the point is, remember, the whole idea is you're doing an asset that you can also use up your exemption. So remember, you could transfer $28 million without any gift tax or estate tax because that's your exemption, and now they're unified. So you could do that without paying any taxes at all, but you have to live by the rules thereafter. You can't use it in the same way. But there are ways in which, as long as you follow the guidelines, there are ways in which you can continue to benefit. You pay rent for a house, for example, or a piece of real estate that you had done for. I'm not arguing it's simple, and I'm not arguing it's hassle-free, but look at what it gets you. It means that you essentially you pay no taxes on your estate with $100 million, for example, or $500 million. I mean, choose your number. So at some point, the hassle factor becomes worth it. And not to mention, when you have that much money, it doesn't affect your life.
Yeah, no, that much money, no.
So I'm saying, so
nothing to him.
You take $20 million that's in investment real estate or in something else. You're not going to the grocery store on that money. You're not doing the things that normal people do with their money. This is sideline money.
A budget. I don't think you've probably ever heard that word. Yeah.
It's sideline money. So you can see how it seems like really bad judgment for somebody who is substantially wealthy to not take some of that money, take it off the table, and get rid of the risk of estate and gift taxes later. It's just and so I want to entertain the thought that maybe Gene Hackman did this. Maybe there is an irrevocable trust out there, and it has a lot of the assets, and then he's not going to be paying taxes. But if he didn't, there's a big tax bill.
Well, I think it's definitely something that his character, Lex Luthor, would have definitely taken care of.
See, now you know that, but I don't know his character. I'm afraid that there's some part of you that knows what she's talking about. And there's a lot of you that are like me. You say, I remember Bonnie and Clyde.
Bonnie and Clyde, they wanted that money, right? They didn't want to just lose that. So I have a feeling, you're saying he probably did the right thing.
All right, that covers the tax, kind of the tax perspective. Let me kind of wrap up here. This video is a little longer than I thought it would be, but this seems to happen a lot. So here are kind of my observations. And some of these things, incidentally, I've already mentioned. They're incorporated, they're peppered throughout our discussion. But I want to kind of summarize. The outdated estate documents, there were changes since '05. And the fact that there's no evidence that there was any estate planning done after that makes me think that the attitude was, I've done it, I'm finished with that now, I'll move on. And that's almost always a mistake in estate planning. Mm-hmm. Things happen, changes happen. In their case, he became more dependent on her. He lost his capacity in many ways. He was suffering from Alzheimer's, but they think that the death was probably attributable more directly to heart factors, cardiovascular things going on. He's 95 years old.
Well, he was still working until really 2017. So there's still money coming in the novels, and he narrated some things. So it wasn't like the acting that we saw, but he was still active.
Yeah. Yeah. So the fact that nothing was done to update these to reflect changes in their life, it's hard to believe there weren't changes to where there were things he might have done different. So that really stands out to me. And another thing that really stands out is the fact that they isolated themselves this way. It always troubles me when people seem to be unwilling to spend money, and that may not have been the driving factor, but perhaps it was. But they chose to live under circumstances where, despite his frailty, despite Hackman's frailty, that in her age, she's 65, so it's not old, but, you would think they would have domestic help. You would think there would be people that would live there. They had the ability to live alone in an isolated place and still be able to get the health care necessary to be able to live a long life and to be suitable to being in that environment. But the decision to live in that environment where you don't want to have any full-time help. And my remarks, as always, in this conversation is as reported. So it appears that they didn't have full-time domestic employees. And it's unflattering in more than one way that somebody with their money would choose to not have people there that would have made all the difference in the world.
Well, even his kids making a little check every now and then. I haven't really heard much about that. How often his kids saw him.
Well, that raises a different question. Yeah. But you're right. I mean, apparently the kids weren't in regular contact. I heard some conversation, one article where I think it was Christopher that said that they touch base once or twice a year or something, but it wasn't with any regularity. But I'm looking specifically at those two, meaning husband and wife. I mean, they were in a position to have whatever they needed and to do the sort of planning they needed. And though we focus on estate planning, remember this is later life planning. So later life planning is not just about your estate planning. It's about your care in that last third of your life. And for some people, that entire third of their life, they're self-sufficient. They continue to be able to manage their own affairs, and that's great. But you don't plan for that, and definitely given their circumstances. So I'm really troubled by the fact that they chose to live this way, which invited a problem like this. And they're both dead for no good reason. Now, I would like to think that if she'd gotten treatment sooner, that she would have lived from this respiratory disease. It's not my impression that this is necessarily fatal. It's not cancer.
Well, oftentimes caretakers, because she was taking care of Gene so much that she probably let some things go.
Well, that's another good point. It kind of flows from this, is that, I'm sure that it was stressful what she was doing. And then Gene, of course, can we believe that just from what we know about him and his health at the end, that he would benefit from having a full-time person around? And I think the answer is yes. And I'm fueled in this argument by somebody who knew them, who posted, I think in response to the People article. And oddly enough, People magazine, turns out that their reporter got access to some of the best information regarding the wills that's out there. So the People magazine gets cited as a source for many, probably half of the articles I read relating to the will came through that research. So anyway, and I think it was in that article that they interviewed somebody who said that she wanted and took pride in taking care of him herself, and that she really wanted to live that life away, and she wanted to do it alone, and was very proprietary even around him. And in some ways that's flattering to her and to him, but in other ways it's not, and certainly not if it affected the kids' relationship. But we know it affected that. They're dead because of it. Mm-hmm. I mean, we can say that. So I'm listing criticisms here or learning opportunities, and that really stands out. I'm really troubled by that because it seems so unnecessary when you have that much money.
Mm-hmm. You can afford the help.
Yeah, we know so many people who are poor and trying to live at home, and middle class trying to live at home, and they're trying to figure out, how do I get care into the house? And they're scrambling to qualify to have Medicare to pay some part of a household visit. It's just, and then here we have these people who clearly could have had that care. And it may tie in, incidentally, if we really want to push the point, if this virus or this airborne thing that was the cause most directly of Betsy's death, had there been somebody in the house to do household duties regularly and more fastidiously, then can we not assume that would not have been contracted, and so she may not have had that illness at all?
Maybe.
So unforeseen succession complications. This was a point that Trust and Will magazine, which is a great source. It's really more for lawyers, but anyway, I really liked their article, and they just brought home how, in many ways, this situation kind of sets the stage for a classic family content or conflict. But it's not happening this way because the way that normally develops was headed off by this bizarre tragedy where, they die as we've just described. So had that not happened, what would have happened here? Well, if it's like that stereotypical case that we so often talk about on this show, and many more, then there would have been lots of litigation, lots of money given to lawyers, all this because there was no serious effort given to insulating a plan against that sort of conflict. You can disarm who you think will be the likely contestants by doing things to make clear what you're doing and why you're doing it. Now, it's possible some of these things were done, again, but based on what we know, there's no evidence of it. So you can have a videotape made when the documents are made. You can do a more updated version of it's not that you do a video will, it's that in the course of the will, there's a video in the execution of the will, there's a video prepared in which, you explain why you're doing what you're doing. And the closer the proximity of that to your death, the better, subject to your being clear-headed, et cetera. So there are lots of qualifications to that. Sometimes it's a bad idea, but the whole idea is that there's this toolbox of things you can do to sort of insulate your estate planning from these likely contests. Now, we can easily ignore this huge failure here where kids are completely wiped out, and the kids apparently don't understand why. If we're to believe these reports, they don't seem to have had a bad relationship with their dad. You had a dad who was isolated in the last 10 plus years of his life, maybe longer. So you really have the stage set for a challenge that might very well have happened had things not occurred as they have here.
Well, had they both even passed, but if he would have passed first.
Oh my gosh. It's definitely. So this was just a sort of sloppiness that it may not impair this situation because this could all turn out well, and by well, I mean I think that he would have wanted his kids to receive a substantial part of his estate. But it could still come up in this case where the substance of that complaint is still there, meaning that you have this document that doesn't reflect probably what his priorities, so it would be alleged what his priorities in fact are. And remember, the argument is not that he loved and cared about his kids. The standard is much lower. Standard is that, would he rather it go to some anonymous charity or his kids? And, so as a child, you don't have to argue. We had this great relationship with my dad. He cared so much about us. You don't have to argue that as a child in order to get the point across that no, if your wife were exhausted and you had no real charities that you're committed to, that in that circumstance you'd want to go to your kids. In other words, I've exhausted everything I care about. Give it to my kids. So it's
last
a low,
resorts.
yeah, but it's a low bar, and it's just there's no evidence of anticipating what just by call it a bizarre series of events has been avoided. So those are the primary points I would raise in discussing this set of facts. We're going to have to follow it.
Oh yeah.
And I won't promise you we'll do a follow-up. If there's nothing interesting more that occurs, then we won't. But if there is, we definitely want to follow up on this. And I'm curious what happens with his estate. I'm really hopeful that his kids are included in some way.
Well, we'll be able to find out.
Yeah. Okay. This has been another episode of Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell & Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.